Welcome back, viewers, to the PI show. We're talking about an asbestos case heard in the Supreme Court of Victoria. Justice Kiru and a jury found in favour of Mr King, a 62-year-old father who's currently living in Hobart. Caroline, it was a jury trial and a jury verdict. What happened?
Well, clearly the onus is on the plaintiff, Mr King, in this case, to show that his development of the disease had arisen from his exposure while employed with James Hardy over 40 years ago. In all these matters, it is clearly on the plaintiff to show this. It's a difficult test. There's a lot of medical evidence that has to be called. The most critical issue in this is what's called the latency period, because people are exposed to asbestos and don't develop this fatal disease until many years later. It was a bit easier in his case because there was evidence that he had only been exposed to asbestos while employed there. Other defendants don't have that advantage.
So Caroline, what has to be established is causation.
Causation.
That the employer caused asbestos, mesothelioma,
correct,
to be
John,
incurred.
Just
That's
on that
right.
issue there, there's an article by the ABC that talks about the third wave of asbestos cases. Now, what it says is this. Initially, the first wave was related to miners and tradespeople, and now they're talking about people that have been involved in home renovations and also housewives or home duties, people that are washing overalls and things like that. Now, it's very alarming because we're in a society now that's renovating a lot of properties, and the properties that might be caught with these asbestos-type materials are properties between 1920 and 1990. So there's a massive window of opportunity for people to contract this disease, and the real problem is, and I've experienced it down at Phillip Island, my neighbour's renovating a house that's got asbestos sheets. Now, fortunately, he's a builder, so he knows the risks, and he said, I'm not ripping it out, I'm just painting over it. So the key to it is not flaking anything, and there's no particles flying around.
Tony, all it takes is to inhale one little leaf, one little fibre.
Yep.
Because once you've inhaled the fibre, that's it. It will germinate.
That takes years.
It will germinate, and in 30 years' time, you will be suffering from the disease.
Yes.
Caroline, how much did this guy get awarded in the Supreme Court?
1.15 million, in fact.
That sounds like a lot of money, John. Most of them don't get that sort of money.
It's a fantastic verdict.
Yes.
And on top of that, the lawyers were awarded indemnity costs,
That's
Tony.
right.
Why would they do that, John?
Well, the lawyers had put in an offer of compromise, which was lower. However, the jury came over with a higher verdict, Tony.
So, viewers, what that means is that there was an offer in writing put by the plaintiff lawyers and the defendant...
To settle the case at a lower rate.
That's right. And the defendant lawyers got a worse result. So, in effect, they've got to pay the majority of the costs.
And, Tony, it was an 8-day hearing.
Yes.
So you can imagine, you know, it's pretty expensive exercise in the Supreme Court.
But I don't think... Most asbestos cases don't get that sort of money. Why did he get over $1 million? I mean, he's 62, so his loss of income's not much.
Tony, I guess that's why the defendant 3 times tried to knock out the jury.
Yes.
Okay.
They made 3 applications to knock out the jury. I think the defendant realised in this instance that the plaintiff was very sympathetic and that the jury may look after him.
Well, and he was very young too, that's the other thing, he was 62. And
young, so to speak, because at the end of the day his working life was really at an end. At 65 most people do stop working.
That's correct, but this is a deadly disease. It's foreseeable he'd be dead within a couple of years.
So you're saying most of the money would have been awarded for pain and suffering, loss of enjoyment of life, and loss of amenities of life.
That's right, and the dependency of his wife and children. So, I mean, his life would have been cut short by at least 15, 20 years possibly because of this.
It's a very sad case, and it just highlights the pitfalls of working with products like the James Hardy
Tony,
products.
it also shows that well, this was the first case run before a jury for asbestos since 1998.
Look, I don't particularly like juries, John, because I think they're too unpredictable. But this is one instance where a jury was very sympathetic. But in most cases, sadly, juries don't know the law. And they hone in on certain facts.
I think with asbestos cases, most of them actually settle before they actually get to get to court. So
The other thing is that defendants don't generally like juries because they know that they're quite sympathetic, and they would be sympathetic for someone who was 62 and dying.
you'd think so.
And so
yet
they'd
in
be
the
more likely to
general-
give a higher damages award in that instance.
Well, that's in this area, but generally defendants do want juries in the wider personal injury community.
If they believe that there's
Credit issues.
significant credit issues.
But,
yes.
but also, you have to remember, the onus is on the plaintiff here to show causation and to show then damage has occurred, which clearly damage has occurred.
And breach. by
And the breach and the lack of foreseeability argument always
Correct.
arises.
Assuming Mr King was exposed to asbestos in, say, 3 different environments, what would you do in those circumstances, John?
That complicates things.
You join all parties,
You'd
wouldn't you?
think you'd join all parties or you try and delineate the parties.
Yes.
But you'd have to then extract, well, what was the exposure at each employer, Tony?
Well, it's pretty common. I mean, traditionally, most cases involving asbestos, they do join more than one party.
And it's foreseeable because someone would work in a number of places which could have potentially exposure to asbestos over the course of working for 20 years.
But Tony, going back to what you were saying about home renovations, and as you know, that's all the rage at the moment, isn't it?
Oh, of course.
And these home renovation shows on TV, they don't sort of give any warnings about
That's a
asbestos.
very good
No,
point,
no,
John.
that ain't
Or anything
That
like
ain't give
that.
too many
Do you see any liability arising there, Tony?
Oh, who knows?
What against Channel 7 on Channel 9?
Well, they're saying to people, go and rip half your home apart.
Yeah, provided... Yeah, the only problem
But
there,
wait a
I
minute,
guess-
what about the asbestos sheets that were there, you know, from 50 years ago?
They won't know about that till 30 years
It's a
later.
bit far-fetched, I would have thought, so...
Well, proximity, Tony? A few issues there?
Look, can I, just before we move on from this and go to the break, just quickly, His Honour Judge Garnett in the Magistrates Court made a ruling in relation to Section 49. In brief, John, what does that mean?
Section 49(1)(8), it's a very recent amendment to the Accident and Compensation Act, allowing issues of dispute between the worker and the work cover agent to go directly into a court proceeding, Tony.
That's already been issued.
Without having to go to conciliation.
And that is to save time and money.
Yes.
It's a pretty good invention, isn't it, Caroline?
Well, it is because people want their work cover dispute resolved quickly, when you issue proceedings in court, it generally takes up to 6 months, and so
get a
you don't
hearing
want
date.
any
That's in
further
the Magistrates
delay.
Court. It's longer in the county court.
Absolutely.
Yes, yes. So, look, the downside is His Honour did say that in complicated matters, in matters that where
Still gotta
there's
go to conciliation.
legal, factual issues which cannot be determined, it's more appropriate to go to conciliation first and then come to the court.
Well, the good thing about the judge is that at least he made a direction that the parties should agree to the matters going to conciliation to try and fast-track it.
Exactly.
Yes.
Look, viewers, we've got to go to the sponsors break, and after the break we're going to Caffey's mailbag. Colin, thanks for coming on board. I appreciate
you.
your
Thank
time.
you, Caroline.
John, thanks again. Stay tuned, viewers. Don't go away.